Hi there. My name is Christina Calicott, and I want to welcome you to the Telluride Library series on Indigenous Environmental Movements. Before I get started, I want to acknowledge that I live and work and come to you today from lands that previously belonged to the Uncompahgre Ute before they were forcibly removed to the Fort Duquesne Reservation in Utah in 1881. So this is a very auspicious time for us to be studying the issue of Indigenous environmental movements. For one thing, President Biden recently named Representative Deborah Haaland as Secretary of the Interior, where if confirmed, she will be the first Native American, man or woman, to achieve the rank of Cabinet Secretary. As Secretary of the Interior, she would oversee the Bureau of Indian Affairs, as well as the Bureau of Land Management, the U.S. Geological Survey, and the National Park Service. The future Secretary Haaland is, of course, an enrolled member of the Laguna Pueblo and a 35th generation New Mexican, not to mention a very progressive Democrat who supports the Green New Deal and Medicare for all. Another big milestone occurred on January 27th of this year, when President Biden signed an executive order that made environmental justice and climate equity a priority for all federal agencies. This is huge. The order created a White House Environmental Justice Advisory Council and an interagency council to ensure what they're calling, quote, a whole of government approach to addressing current and historical environmental injustices, unquote. Perhaps even more important for our purposes today, he also released a memorandum on tribal consultation that affirmed the administration's respect for the sovereignty of Indigenous nations, or what most of us know as tribes. This memorandum harkens back to an executive order signed by President Bill Clinton to establish formal mechanisms for consultation with tribal governments. However, that order was never fully manifested, and President Biden's 2021 memorandum complies with the requests of tribal governments to establish a concrete timeline for the completion of these actions. Tribal leaders are heralding Biden's actions as a step in the right direction, and a big one. So what I want to do right now, in preparation for you to watch Warrior Women and to meet with Madonna Thunderhawk and her daughter, Marcella Gilbert, later, is to place Biden's executive orders into context. Why do we talk about nations when we talk about tribes? Why is consultation important? What does national sovereignty have to do with environmental activism? I'm going to give a brief history lesson here, the kind of history that should be taught in every US history class but isn't. If you want to skip my little fireside chat, I highly recommend that you read the first chapter of Peter Matheson's book, In the Spirit of Crazy Horse. That chapter is a very straightforward and easy to read history of US law pertaining to Native nations. It focuses on the story of the Lakota and the outright theft of the Black Hills. But these laws, regulations, and agencies are generally the same across Indian country. So the Lakota story is relevant to much of the rest of the United States. It also happens to be the history of the Standing Rock Sioux Nation, who of course are the protagonists of the No DAPL movement, which we'll be studying later in this series. One thing that I, as an anthropologist, want to be sure and establish from the outset is that prior to the arrival of European colonists on American soil, the Americas were not a sparsely inhabited continent with wide open spaces free for the taking. In fact, what we know now is that it was rather heavily populated, and that the peoples who made North America their home spoke many languages, they had their own systems of government, and they had highly developed cultures with their own forms of art and religion, science and economy, recreation and cuisine. Some existed as loosely organized and decentralized entities, while others operated within formal confederations. In fact, the US Constitution and our own democratic system of government are largely modeled on indigenous forms of governance that the founding fathers found to be both effective and egalitarian. Although, of course, the fathers omitted the part about women's equality with men and women's important role in ensuring effective governance, but that's a story for another time. In the early days of its post-revolutionary nationhood, the United States was a pariah state, one that had thrown off the mantle of its colonial rulers through revolution. Indigenous scholars argue that the young US government, in order to achieve legitimacy as a nation state, set about signing treaties with indigenous nations whose own sovereignty had already been established by European colonial nations and solidified through treaty with them. Now, I'll define sovereignty briefly here as the authority of a state to govern itself or another state. It pertains to matters of self-governance and self-determination. When we speak of Indigenous sovereignty, we're talking about the rights of Indigenous peoples to govern themselves and their lands as fully embodied nations, the same as any other country, domestic or foreign, according to their own will and customs, without interference from outside actors. Now, as the US began expanding beyond the original 13 colonies and moving westward, it of course encountered Indigenous peoples, many of whom presented a very formidable barrier to colonial expansion. Therefore, in addition to generating legitimacy for an outlaw nation, a second and increasingly important purpose of treaty negotiations was, of course, to obtain title for Indigenous lands. Early US legal scholars had no illusions about the unassailable sovereignty of Indigenous nations and the inalienability of their lands. Supreme Court Chief Justice John Marshall acknowledged the logistical challenges to US expansion posed by Indigenous sovereignty, noting that Indigenous rights could even disrupt the territorial integrity of the original 13 states. Subsequently, in a series of court decisions known as the Marshall Trilogy or the Marshall Doctrine, Chief Justice Marshall unilaterally redefined the status of Indigenous nations as quote unquote domestic dependent nations with limited sovereignty. Thus began over 2 centuries of broken treaties and the unilateral legal contortionism through which the US federal government justified its seizure of Indigenous lands from coast to coast. In the Western United States, we see one after another tribal nations sign treaties in good faith, only to have the federal government unilaterally abrogate those treaties as soon as gold, silver, or other valuable natural resources were discovered on Indian treaty lands. To this day, Indian nations remain the rightful owners of such regions as the Black Hills, considered the sacred heart of the Lakota people, or the vast sagebrush-covered mountains of Nevada known as New Segovia to the Western Shoshone. And struggles for these lands continue. The No Dapple protest, for example, at Standing Rock, took place on unceded treaty lands of the Great Sioux Nation. Here in the San Juan Mountains of Colorado, the so-called pathfinder of the San Juans, Otto Mears, paid men of the Uncompahgre Ute tribe $2 each to sign a treaty ceding the last of their lands to the US government. When he was hauled in front of the Senate and questioned regarding these apparently unethical actions, Mears replied that the Utes had told him that $2 in hand was worth more than the government's empty promise of $50,000, a reference to the series of broken treaties that had preceded the Treaty of 1880. In 1881, the Ute people were forcibly removed from the Uncompahgre Valley and from the surrounding region to make way for white settlers, including some of the families whose descendants make their homes there today. So I want you to stick with me for a little bit longer while we go through a few more pieces of federal legislation that lead us to where we are today. For one thing, I want to be clear that during the 1800s, while the federal government was engaged in signing treaties with Indigenous nations, it also had a de facto policy of extermination of Indigenous peoples. We've all heard of the hideous massacres at places like Sand Creek and Wounded Knee, which were just 2 of many. There were also massive forced relocation efforts, such as the Trail of Tears, during which an estimated 55% of victims perished, and the Long Walk to Bosque Redondo, where the internment of Navajo people, or Dene as they prefer to be called, became a model for Hitler's internment of the Jews during the Holocaust. Particularly pertinent to our subject matter of environmental issues, the US military engaged in a concerted effort to drive the bison to the brink of extinction as a strategy for subduing the Plains Indians, for whom the buffalo was not only a major food source, but also the cornerstone of their cultures. So, with the military might of the Indian nations subdued and their survivors largely confined to reservations, the US government began its slow march toward eliminating Indigenous nations altogether. An important step in this march was the passage of legislation known as the General Allotment Act, or the Dawes Act, passed in 1887. The Dawes Act was explicitly designed as a tool to destroy the social cohesion of the Native nations and to foster the assimilation of Indian people to white society by turning them into farmers. Basically, the Dawes Act divided up reservation lands, lands that were collectively owned and used, and parceled them out to individuals and families for private ownership at a fixed rate of 160 acres per family. Leftover acreage, of which there was a considerable amount, was sold off to non-Indigenous buyers for a fraction of its value. After 25 years, Indian people were also allowed to sell their individual parcels, which many families, having been reduced to poverty in the process, were forced to do. In sum, the Dawes Act served to dispossess the Indigenous nations of the vast majority of their remaining land base, while also destroying their social structure and traditional culture. Within 50 years of the Dawes Act, two-thirds of the land that Indigenous nations had held at the passage of the Act had been sold to non-Indigenous people or had been subsumed into the growing system of federal public lands, including the budding national park system. Thus, we're left with the great irony that Indigenous nations were disparaged and destroyed in no small part due to their practice of collective land ownership. Having destroyed their cultures and seized their lands, the US government took that land and put it back under collective ownership in what we now enjoy as our federal public lands. The policy of allotment was so destructive that in the 1920s, a federal commission was formed to study the Indian problem and to determine how best to end the financial drain on federal coffers posed by Indian nations. A study known as the Merriam Report concluded that remaining tribal lands should be maintained in whole rather than the fragmentation that had been taking place under the Dawes Act, and that their mineral resources, such as coal and uranium, should be leased as an income generating mechanism. The recommendations of the Merriam Report became a law known as the Indian Reorganization Act, or the IRA, whereby tribal councils were formed as units of the Bureau of Indian Affairs. These councils were explicitly designed to serve as agents for the leasing of mineral resources on native lands, and their decisions were subject to the authority of the Secretary of the Interior. Again, another reason that it's so important to have an Indigenous woman in that role. The Indian Reorganization Act, passed in 1934, was foisted upon tribes, often against their express wishes and acts of resistance. Now, as I noted at the outset, Indigenous nations already had their own systems of governance. These systems were usually based on consensus-style decision-making. The Indian Reorganization Act replaced traditional governance with a divisive, majority-style system that was imposed from the outside. Not only did the IRA serve to divest Indian nations of control over their own lands and resources, it also fostered deep political and cultural divisions within reservation communities. These historical factors are what set the stage for contemporary conflicts, such as the occupation of Pine Ridge that led to the death of an FBI officer and the imprisonment of Leonard Peltier, as well as the relocation of Dene or Navajo people from their traditional sacred lands to make way for Peabody coal. After the dust settled from World War II, a new movement took hold in DC to terminate Indian nations altogether. This effort focused on those tribes whose reservations were not useful as profit-generating enterprises. The man who was put in charge of this effort was one Dillon S. Meyer, who had made a name for himself as head of internment of Japanese Americans during World War II. In 1953, Congress passed legislation known as the Termination Act, which set in motion a series of laws that unilaterally dissolved over 100 Indian nations within 5 years. Many nations actively resisted termination, including through direct action, such as the occupation of tribal headquarters. In 1956, Congress followed termination with passage of the Relocation Act, which provided for the relocation of Native Americans from reservations to urban centers. At the same time, state and federal dollars allocated for the provision of state services on reservations steadily diminished, resulting in the crumbling infrastructure, poor educational systems, and lack of health services with which many outsiders equate Indian country. I want to emphasize that poverty, alcoholism, poor health, and other forms of destitution are not characteristics of indigeneity. Instead, they are the outcomes of centuries of colonial policy designed explicitly to ensure the cultural genocide and material eradication of entire groups of people. Within 5 years of passage of the Relocation Act, over 35,000 Native Americans have moved from the reservation to places like Denver, LA, and Minneapolis. By 1980, that number had grown to almost 900,000, or almost half of Native Americans living in the US. It was within these communities of displaced peoples that the American Indian movement took root. Now, as we'll see in the film Warrior Women and in our discussion with Madonna and Marcy later on, we can draw a direct line between the radicalization of Native Americans in urban centers, the formation of AIM, and the eventual passage of the United Nations Declaration of the Rights of Indigenous Peoples and other forms of international law and normative documents that are designed to protect the rights of Indigenous peoples and, by association, the rights of the lands that they occupy or that they traditionally claimed as theirs. In Lakota tradition, there's a phrase, Mitakwi Oyasin. This can be translated as a greeting, all my relations, or as a statement, all things are related. Now, Indigenous cultures on a global scale are widely diverse, and we can't paint them all with the same brush. However, it is generally acknowledged that a common thread of many, if not most, Indigenous cultures, and certainly those of Native North America, is the recognition of the interrelatedness of all forms of being. This includes not just living beings like animals and plants, but also what Western culture might consider non-living, beings like rivers or lakes, mountains, the water more broadly, for example. Implicit in this concept of interrelatedness is also the concept of reciprocal responsibility, that humans have a responsibility to the earth and its beings to care for them and protect them, while these beings of the earth, the water, the animals, etc., also have a responsibility to provide for the well-being of humans. It was this reciprocal responsibility that lay at the heart of the No Dapple protests and the cry of the water protectors. It is also this responsibility that has been codified into international law and the protection of Indigenous lands therein. In its introduction to conservation law, the Indian Law Resource Center wrote, and I quote, "When Indian leaders from the Americas went to the United Nations in 1977, demanding recognition of their human rights, especially their rights as distinct peoples, they spoke at length about the need to protect the environment, including those creatures that, quote, cannot speak for themselves, unquote. Old hands at the UN and delegates of member states thought that these Indigenous speakers didn't understand that the conference was devoted to human rights. The draft Declaration of Rights that the Indigenous participants proposed to the UN prominently included the right to environmental protection, a concept all but unknown at the time. For these Indigenous leaders from North, Central, and South America, the human rights essential for their survival as nations, peoples, and cultures were inextricably intertwined with the well-being and protection of the natural world. That proposed declaration was taken up by the United Nations, and it led to the adoption 30 years later of the UN Declaration on the Rights of Indigenous Peoples. Now, there are a number of international legal instruments that seek to protect Indigenous rights, but the two most important are the UNDRIP, the Declaration on the Rights of Indigenous Peoples, and Convention 169 of the International Labor Organization. Both of these documents codify the importance of something known as free, prior, and informed consent. FPIC, as this doctrine is known, states that Indigenous peoples have the right to consent or not to any project that will affect them or their lands. In many nations, however, this very central and fundamental right has been weakly reconstrued as consultation. In the United States, Section 106 of the National Historic Preservation Act requires consultation with tribes prior to the enactment of any projects, such as infrastructure or pipelines, that may affect them or their lands. However, proper consultation may be effected simply by sending a letter or even an email to the proper tribal officer. Indigenous activists see consultation as one of many check boxes on the checklist of perfunctory actions to be performed prior to government or industry doing what it had already planned to do in the first place. This has been the case, for example, with the Standing Rock situation. I attended a webinar just last night with Indigenous leaders from the Keystone, Standing Rock, and Bears Ears movements. They're very glad to see the Biden administration moving toward proper consultation with tribes, but they also demand the implementation of the doctrine of free, prior, and informed consent before Indigenous rights can be truly respected. So that's all for now. Please enjoy the movie Warrior Women. There's a lot of information in there, but there's also a lot of laughter and joy and resilience. If you're interested in reading any of the articles that I've referenced, or if you want further information on these subjects, please contact me or Laura. And we'll see you via Zoom on February 17th at 6 p.m. sharp. See you there.